The Supreme Court has officially released a fresh order in a major constitutional battle surrounding Missouri's Second Amendment Preservation Act. And this development has created a new wave of questions, confusion, and speculation about what happens next. This case has been bouncing between courts for years, and every time it reaches the Supreme Court, people hope for clarity. Yet instead of a clear conclusion, we now have another decision that keeps this case alive, but unresolved. So today, I want to walk you through exactly what the Supreme Court just did, why it matters, and what the next steps look like for Missouri, for gun owners, and for the broader Second Amendment debate nationwide. But before we dive deeper, I want you to take just a second and check something important. Make sure you are actually subscribed to the channel. Every time I remind viewers about this, I get dozens of messages saying they were silently unsubscribed. So double check that you're still subscribed. And if you're not, now is the perfect time to hit that button. It helps the channel tremendously and ensures you never miss critical updates like this. Now let's get into this case, because a lot just happened. The law at the center of this fight is Missouri's Second Amendment Preservation Act, also known as SAPA. This law was passed in 2021, and its goal was straightforward. Missouri wanted to assert its own interpretation of the Second Amendment and prevent its officers, agencies, and public officials from helping federal agents enforce gun laws that the state believed violated citizens' constitutional rights. Under SAPA, Missouri law enforcement officers were specifically prohibited from assisting federal agencies in carrying out federal gun regulations that Missouri considered unconstitutional. And on top of that, SAPA created a unique civil enforcement mechanism that allowed regular Missouri citizens to sue any state official who tried to help federal agents enforce unconstitutional gun rules. This law immediately became one of the boldest attempts in the country to challenge federal gun regulations. It essentially turned the enforcement power toward the people themselves and took it out of the hands of state government. That alone was enough to draw national attention and legal action. Not surprisingly, the law was immediately opposed by the Biden administration. The DOJ sued Missouri, arguing that SAPA violated the Constitution's Supremacy Clause and interfered with federal law enforcement. When the case reached the district court, the judge ruled entirely in favor of the Biden administration, striking down the entire SAPA law. Missouri appealed to the Eighth Circuit, but before that court even heard all arguments, Missouri sought an emergency stay, hoping to keep the law in effect while litigation continued. That request was denied. That denial was significant enough that Missouri took the fight directly to the Supreme Court, asking for emergency intervention. The justices responded with an 8-1 denial. Only Justice Clarence Thomas sided with Missouri and believed the stay should be granted. The rest of the court refused to block the lower court ruling, meaning SAPA remained completely unenforceable. After that, the case returned to the Eighth Circuit. The appeals court reviewed the case quickly, holding expedited arguments due to the law's importance. But in the end, they once again ruled against Missouri and reaffirmed the lower court's decision to strike SAPA down entirely. From there, Missouri filed yet another emergency request with the Supreme Court. They argue that the appeals court had misunderstood the nature of SAPA and ignored existing Supreme Court precedent. One thing Missouri emphasized strongly was that the appeals court admitted parts of the law's structure and operation could be valid, but the court still rejected it because they disagreed with its underlying Second Amendment purpose. Missouri said this alone showed judicial bias and required Supreme Court review. They also argue that the appeals court used an extremely unusual interpretation of state enforcement. The appeals court claimed that simply refusing to help federal agents, just non-enforcement, counted as enforcement. Missouri argued this was legally absurd. If choosing not to enforce something is treated as enforcement, every state in the country could be sued simply for choosing not to take an action. That would flip constitutional protections upside down. But here's where the case took a turn that almost nobody expected. After the Biden administration was replaced by the Trump administration, the DOJ suddenly shifted its position. For months, the Trump DOJ didn't respond to the Supreme Court at all. They took delay after delay. Then, in a surprising filing, the Trump administration, same time, they also argued that the district court's original judgment went too far. They said the injunction that blocked all of SAPA was overly broad, and that some parts of SAPA might be constitutional under the anti-commandeering doctrine. This doctrine is a major constitutional principle that prevents the federal government from forcing states to carry out federal enforcement. In other words, states cannot be required to help enforce federal gun laws. They can choose to assist, but they cannot be forced. The Trump DOJ said that the lower court's ruling blocked parts of SAPA that might actually fall under that constitutional protection. So their solution was simple. Once the case returns to the district court, the Trump administration promised to release part of the earlier judgment. This means the federal government itself would voluntarily scale back the injunction and allow some sections of SAPA to take effect again. Missouri's lawyers told the Supreme Court that this move, the federal government admitting part of the ruling was flawed, is the reason the Supreme Court should take the case. But despite that argument, the Supreme Court once again denied emergency review. They agreed with the Trump administration's position and sent the case back down to the lower courts without taking direct action. That brings us to where we stand now. This case is not over. It's not even close to over. The Supreme Court's denial does not mean they agree with the lower court. It simply means they won't intervene yet. And because the Trump DOJ has already committed in writing to drop parts of the earlier injunction, Missouri may soon be able to enforce part of SAPA again while the case continues. What happens next will depend heavily on how the district court responds. The federal government plans to remove part of the injunction, but the district court technically has the authority to push back. If they choose to fight the DOJ's position, that could trigger another series of appeals. More likely, however, the court will accept the federal government's narrowing of the injunction, meaning portions of SAPA will come back to life. Once that happens, Missouri will need to carefully determine which parts of the law they can enforce without violating the narrowed injunction. That puts responsibility back on the state to navigate the gray areas and avoid triggering new legal challenges. The Trump DOJ made clear in their filing that they want to see how certain parts of SAPA operate in real-world practice. They want to observe how the state handles non-enforcement of federal gun laws and how citizens use the lawsuit mechanism. The ultimate question now becomes, will the Trump administration keep its word? They told the Supreme Court that they intend to free up part of the law at the district court level. If they follow through, that gives Missouri at least a partial victory and opens the door for further arguments. If they don't follow through, the state will need to raise that issue immediately and potentially seek new appeals. But regardless of what happens next, this case is heading toward a full trial on the merits. The district court will eventually issue a permanent ruling on the constitutionality of the entire SAPA Act. Many expect the district court to strike the entire law down again. If that happens, Missouri will appeal once more, and the case may eventually return to the Supreme Court, but at that point, the justices will have the full record, not just an emergency request, and that is where the real fight will happen. Right now, nothing is final. Nothing is settled. This case is alive, and some parts of SAPA may soon be active again. The Supreme Court didn't kill the case. They simply chose not to intervene early. There is still a long legal road ahead, and this issue is far from resolved as developments unfold. I'll keep tracking every move, every filing, and every statement. This case has massive implications not just for Missouri, but for any state trying to assert its own Second Amendment protections and resist federal enforcement in specific situations. It's a test of state sovereignty, federal power, and constitutional interpretation, all wrapped into one battle. As updates come out, I'll continue to bring you clear, detailed coverage. If you found this breakdown helpful, liking, commenting, and subscribing truly makes a huge difference. And if you want more insights, stay tuned. YouTube should have a couple videos on the screen that it thinks you'll find useful. And remember, this country was built by informed citizens who understood their rights, and it'll be protected by those same informed citizens today.